Committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Implementation of FinCEN's Customer Due Diligence Rule, Financial Institution Perspective. I'd like to thank the witnesses for appearing today. We appreciate your participation and look forward to your discussion. In the interest of time, the ranking member and I have agreed to forego opening statements and move directly to witness testimony. Today, we welcome the testimony of Mr. Greg Baer, President, the Clearinghouse Association, Mr. Carlton Green, Partner, Crowell and Mooring, Mr. Gary Coleman, Executive Director of the FACT Coalition, and Ms. Dalia Martinez, Executive Vice President, International Bank of Commerce, on behalf of the Mid-Sized Bank Coalition of America. Each will be recognized for 5 minutes to give an oral presentation or testimony. Without objection, each of your written statements will be made part of the record. A little bit on the lighting system. Green means go, yellow means you have a minute to wrap up, and red means you should be closing up and moving on. We do have votes in the 10:30 to 11 o'clock range, somewhere in there. We hope to be able to get as far down the road as we can. That's why we've done away with opening statements. Depending on how many participants we have in the committee today, we will continue after that, after votes, if we need to. So hopefully we'll get a lot done between now and then. And with that, Mr. Baer, you're recognized for 5 minutes.
Thank you, Chairman Lukemeyer, Ranking Member Maloney, members of the subcommittee. Thanks for the opportunity to testify today on FinCEN's CDD rule. It's a particular pleasure testifying before you, Mr. Chairman, and the ranking member, with whom it's been a true pleasure working with you and your staff on these issues now for some time. The Clearinghouse believes that the FinCEN's CDD rule and its beneficial ownership requirement can provide law enforcement with useful information as it seeks to learn more about suspect companies. We particularly appreciate FinCEN's decision to grant financial institutions some flexibility in how they collect and certify beneficial ownership information, which was the product of a laudable notice and comment process by FinCEN. We do, however, have one primary concern with the final rule and broader concerns about guidance used to interpret it and the examination process that's expected to enforce it. As for the rule, it requires covered financial institutions to reconfirm the beneficial owners of a customer each time the customer opens an account. This requirement is burdensome for customers that routinely open multiple accounts on the same day or within a short period of time. For example, title companies can open multiple accounts daily to assist in closing real estate transactions, and large companies frequently open accounts for many reasons. The cost and customer inconvenience of reconfirming ownership with each new account do not appear to come with any corresponding benefit, as there generally is no reason to believe that the opening of a new account is evidence that the ownership of the customer has changed. The new account requirement is complicated further by guidance released by FinCEN on April 3rd in the form of FAQs. While the Clearinghouse generally appreciates FinCEN's efforts to provide additional guidance, unfortunately, in some areas, the guidance has expanded rather than interpreted the final rule and in unexpected ways. Most significantly, FAQ 12 states that even the rollover or auto-renewal of an account, for example, a deposit or a loan, constitutes a new account. Again, there is no reason to believe that the rollover of a one-month CD is evidence of a change in ownership in the customer. Since adoption of the CDD rule in 2016, financial institutions have invested millions and rebuilt their internal systems, which would need to be significantly modified to accommodate this direction, which came only 1 month before the go-live date. The FAQ 12 guidance is even more troubling, given that these products include contractual provisions that require financial institutions to auto-renew for customers without interruption. Therefore, on May 11, financial institutions will be forced to choose between breaching their contracts with customers or following the FAQ. We note that FinCEN in its FAQs has attempted to resolve this issue by providing that during the initial certification of beneficial ownership, the customer can simply agree to notify of any future change. We hope and expect that FinCEN will revisit the question of existing accounts where that agreement has not already been obtained. However, even as FinCEN considers this issue, we are quite concerned that examiners at the regulatory agencies will treat guidance as a binding rule and cite banks for violations of law for honoring their contracts in their traditional zero-tolerance approach to AML compliance. Of course, new beneficial ownership requirements for banks highlight the need for broader legislation to prohibit the formation of anonymous companies, as many criminals launder money by forming LLCs and using them to hold real estate or other valuables, all without even touching the banking system. For this reason, we continue to support your legislation ending anonymous ownership of U.S. companies. With respect to implementation of the CDD rule, we believe that FinCEN compliance examinations and the BSA compliance examinations should follow FinCEN's rule and not seek to amend or interpret it, either at the agency level or through ad hoc examiner judgment. For example, public reports have indicated that the banking agencies have considered directing institutions to collect beneficial ownership at a 10% equity threshold in some cases. However, FinCEN was very clear in its rule that the standard is 25%. More broadly, my written testimony describes the profound dysfunction in the current AML regime, where banks are judged on SARs they don't file rather than the value of the ones they do, where no priorities are set, and where the hallmarks of the regime are box checking and compliance for compliance sake. The result is a system that is doing far less to assist law enforcement and national security than it could, and a system with extraordinary collateral costs. Everything from pushing LMI customers out of the banking system and into the hands of check cashers and payday lenders, to forcing global banks to exit certain countries or regions at risk of sanction. In the now 2 years since we began raising these issues, it has been gratifying to see the building of a broad bipartisan consensus that major changes are necessary to the system. But I am sad to report that by all accounts, nothing much has changed in the banking agency's examination and enforcement of the regime. Hearings like this and the draft legislation under consideration are important steps in turning this consensus into real reform. Thank you very much.
Thank you, Mr. Bear. Mr. Green, you're recognized for 5 minutes. Please turn on your microphone, and if you would pull those close to you, those things do move.
Can you hear me now?
So that they're not too far away from it. Thank you.
Very well. Thank you, Mr. Chairman. I appreciate the opportunity to address the subcommittee. My name is Carlton Green. I'm a partner at Crowell & Mooring. I'm formerly the chief counsel of FinCEN, and before that served a number of years at Treasury working for the Office of Foreign Assets Control on sanctions activities against U.S. sanctions regimes against Iran, North Korea, transnational criminal organizations, and terrorist actors. Since leaving FinCEN, I've been now 2 years in private practice working in the economic sanctions and anti-money laundering areas, primarily for financial industry clients, and I think it's given me a balanced view on the critical mission that FinCEN plays, but also the enormous efforts that private industry puts into complying with the Bank Secrecy Act, the burdens associated with it, how seriously they take it, and how much they work every day to try and comply with it, much of which is not seen by regulators. There's just a few points I wanted to make today. One is that I think the CDD rule represents a very important advance in the information available to FinCEN. Information on beneficial owners, I think, will allow FinCEN to draw all kinds of connections that were not previously available to it in the fight to detect and deter financial crime. I think that's critical information. I think that FinCEN deserves credit for having gotten this rule across the line. This is a rule that's been 10 years in the making. FinCEN conducted extensive public outreach associated with the rule. It incorporated a lot of the comments that industry provided. It showed a willingness to engage with folks and have a real back and forth dialogue. I also think that the FAQs that FinCEN put out again shows considerable responsiveness to the concerns that industry raised about the rule and the questions that they had about the rule. I think that kind of partnership bodes well for the future of the rule and its implementation. On the banking side, I think that banks and other covered financial institutions likewise put an enormous amount of effort into informing FinCEN's work on the rule, helping it to understand what kind of ideas would impose impossible burdens on the industry or otherwise wouldn't generate the kind of benefits FinCEN was hoping for. I know that the CDD rule comes on top of the many burdens that these institutions already face, and I know firsthand from my experience in private practice how much time, effort, expense goes into maintaining AML compliance programs, much of which is never seen by regulators. I know also that the professionalism with which every financial institution I've dealt with has approached this issue. So I think there's a lot of credit to be given on both ends. A few points about the rule itself and about the future of the AML regime. I think the FAQs, although they provide important interpretive guidance and have solved a number of the problems raised by industry about the rule, there are a number of compliance questions that still remain out there, and I've given a list of several of these in my testimony. I think my hope is that FinCEN will continue to work closely with the regulated community to address these questions, to provide public guidance where possible on them, but always to listen and offer its thoughts on the approach to these so that industry knows the way to go forward and that implementation is reasonable and possible. I also hope that in the early years of implementing the rule that they will be lenient about enforcement, understanding the inevitable but unexpected obstacles that will arise. The second point I wanted to raise is a broader issue about AML regulation and relates to FinCEN's relationships with the prudential banking regulators. One of the concerns I have, and I think I share with Mr. Baer, is that because FinCEN has delegated examination authority to the federal banking regulators, to the federal functional regulators, I should say more broadly, and because these agencies have use their own independent authorities to enforce Bank Secrecy Act obligations, I think there's some risk there that there will be divergent interpretations of the Bank Secrecy Act, or that enforcement priorities across all these different agencies will not necessarily line up with those that most advance FinCEN's mission of detecting and deterring financial crime. FinCEN, I think, is uniquely positioned in that it has access to financial threat information, and it also understands the regulatory process. And I think it's uniquely positioned to balance those two together to ensure that enforcement is calibrated to the actual needs to address financial threats. In the absence of that dual knowledge, I think there's a potential for overly formalistic enforcement of the Bank Secrecy Act. I'm happy to comment further if needed. Thank you.
Thank you, Mr. Green. Appreciate your testimony. Mr. Coleman, you're recognized for 5 minutes.
Chairman Lukemeyer, Ranking Member Clay, members of the subcommittee, thank you for the opportunity to appear before you. On behalf of the Financial Accountability and Corporate Transparency Coalition, I appreciate the opportunity to discuss FinCEN's customer due diligence rule and the importance of collecting beneficial ownership information. This remains a critical element in the larger effort to address grand corruption and the nexus between secrecy jurisdictions, crime, corruption, human rights, and national security. FACT Coalition is a nonpartisan alliance of more than 100 state, national, and international organizations working to combat the harmful impacts of corrupt financial practices. Before addressing the particulars of the CDD rule, I thought it was important to review why the collection of this information matters. As detailed further in my written testimony, the rule is a positive step forward but falls short of what is needed to protect the integrity of our financial system. Anonymous companies have become the vehicle of choice for drug cartels, organized crime, corrupt foreign officials, and others who need to launder money. These entities are able to profit from these funds, prop up their regimes, and engage in a host of harmful actions. A few quick examples. Moldovan gang used anonymous companies from Kansas, Missouri, and Ohio to trick victims from overseas in a $6 million human trafficking scheme. Traffickers in counterfeit and other illicit goods and services often hide behind corporate entities to make it more difficult for legitimate businesses to honestly engage in global commerce. As Congress considers new sanctions to counter North Korean threats, the committee should take note of a U.S. Department of Justice case charging a Chinese national and several colleagues with violating U.S. sanctions laws by working with a blacklisted North Korean bank to set up shell companies in Hong Kong and elsewhere to hide the business they were doing with North Korean companies that helped them to develop nuclear weapons. We agree on the need for the CDD rule as a step toward a comprehensive approach to prevent the abuse of anonymous companies and launder money through our financial system. The rule was published in 2016. Financial institutions have had 2 years to prepare for the implementation of the rule. Many U.S. financial institutions already routinely collect beneficial ownership information as part of their Know Your Customer obligations. We do not see a need for the delay in the implementation rule. We have no position on whether or not, if there are good faith efforts that have been made by financial institutions to have reasonable accommodation on enforcement actions. The coalition does have a concern about the rule's definition of beneficial owner. The rule does exclude the concept of entitlement to funds, thereby enabling a corporate officer to be deemed the beneficial owner of a corporation if that officer has no ownership role or entitlement to the corporation's funds. The coalition favors a consensus definition that was already approved overwhelmingly by Congress in last year's National Defense Authorization Act. In the NDAA of fiscal year 2018, a provision was included to require the Department of Defense to collect beneficial ownership information when leasing high-security office space. That definition, with its focus on natural persons who ultimately control or benefit from a legal entity, is important to prevent the shell games in which one company owns another, which in turn owns another, and so on, all to obfuscate the name of the individuals who exercise ultimate control. The rule is only one part of an overall strategy to address the abuse of anonymous companies. Bad actors have established U.S. companies to purchase real estate, aircraft, and other large-ticket items with cash. Companies have been created in the U.S. only to route money from one jurisdiction to another, bypassing the U.S. banking system. While financial institutions represent the largest gatekeeper to the U.S. financial system, they are not the only gatekeepers, and as such, Congress should be looking beyond the rule. There are at least 2 proposals currently pending in the House Financial Services Committee to strengthen corporate transparency by improving beneficial ownership disclosures. We thank Chairman Luke DeMeyer for his leadership, along with Chairman Pierce, for sponsoring the Counterterrorism and Illicit Finance Act, and Representatives Pete King and Carolyn Maloney for co-sponsoring the Corporate Transparency Act. Both proposals require companies to name the beneficial owners at the time of formation, and both include language consistent with last year's NDAA. The CDD rule, the NDAA provision, and Treasury's geographic targeting orders are all important steps, but they are not a substitute for a consistent national standard that levels the playing field for all states and corporate entities. Thank you, and I look forward to any questions.
Thank you, Mr. Common. Ms. Martinez, recognized for 5 minutes. Welcome.
Chairman Lukemeyer and members of the subcommittee, I am honored to have this opportunity to present testimony today. I am Dalia F. Martinez, Executive Vice President and Corporate Bank Secrecy Act Officer for International Bank of Commerce. IBC Bank Laredo is a member of International Bankshares Corporation, a $12.2 billion multi-bank financial holding company in Laredo, Texas. We have 192 branches and more than 294 ATMs serving 90 communities in Texas and Oklahoma. I am speaking to you today representing the Mid-Sized Bank Coalition of America, the voice of 88 community banks with headquarters in 34 states. MBCA banks are primarily between 10 and $50 billion in assets, with more than 10,000 branches in all 50 states with deposits of $1.2 trillion. MBCA banks represent, service, and support millions of customers. I've held the position of BSA officer at IBC for more than 27 years. BSA compliance is a top priority for us, and I have seen firsthand how BSA regulations have evolved, the burden they have placed on our bank, and how these regulations have sometimes ended up harming rather than helping our most important asset, our customers. I would like to focus on 4 points in my testimony today. First, compliance with the CDD rule is very expensive and burdensome. IBC has spent 2,912 hours in design and testing, 7,859 hours in training 2,142 employees and officers preparing to comply with this regulation. These expenditures are on top of the $5 million a year we currently spend to comply with existing BSA AML regulations. Every hour a bank employee spends on regulatory compliance is an hour that employee is not able to spend on what we value most, helping our customers achieve financial success. Second, the CDD rule has many gray areas that are difficult to implement. Let me provide you an example that illustrates this. Bank frontline employees, who are typically not schooled in complicated business structures, are required to capture beneficial ownership information when an account is opened. But the individual opening the account on behalf of the company is usually a control person at the company and not the actual business owner. While in some cases the control person may have knowledge of the ownership structure of the company, they often will not have the identification required for the CDD requirement. This may result in accounts being turned away and delays in opening accounts. Third, the rule puts a burden on banks to ensure the information customer provides is accurate, but banks are not given the tools they need to make that determination. Banks can rely on the information that customers disclose about the ownership structure of the company only so long as the financial institution does not have knowledge of facts that would reasonably call into question the reliability of the information. However, FinCEN does not define having knowledge. Financial institutions have millions of records. Are we to comb through all our records to ensure information provided on a beneficial ownership attestation does not conflict with a document that already exists within the bank? Unlike some countries, the United States does not maintain a national database of business ownership information that a financial institution can rely on. Tools and guidance from FinCEN designed to help banks verify customer information are needed. Fourth, while FinCEN has provided some guidance to banks in the form of FAQs, some of the FAQs are not clear, and others create an even greater burden on banks and ultimately bank customers. One such example is with certificates of deposits that auto-renew. These CDs are for a specific term and rate. Upon maturity, the CD renews and the customer never has to come to the bank as renewal information is mailed to the customer. FinCEN FAQs state that upon the first auto-renewal of a CD established prior to May 11, 2018, the financial institution must obtain the beneficial ownership and CDD information. This means banks will need to contact their customers to try to obtain the beneficial ownership information. From my 39 years in banking, I can tell you customers do not update their phone records and email addresses with the bank on a regular basis. Therefore, we will most likely have to rely on mail. If the customer does not respond to the bank's request, are we to return the funds to the customer or track exceptions? Every time a bank makes an exception, the exception is tracked for BSA exam purposes and is subject to second guessing after the fact. Again, this reality will lead to even more de-risking, which will harm bank customers, especially small business customers who are not exempt from any of these regulations. In closing, on behalf of IBC and MBCA, I hope I have conveyed to you that regulatory costs and burdens imposed on banks affect our nation's small businesses. It is critically important that FinCEN provide clear and effective guidance. Otherwise, our prudential regulators will be left to their own interpretations, and ultimately, this will result in customers simply being driven out of the traditional banking system. Thank you.
Thank you, Ms. Martinez. With that, we'll begin our questions. I'll recognize myself for 5 minutes. One of the concerns that we've had, and Chairman Pierce and I are working on a BSA ML bill, and part of it is to get this beneficial ownership situation resolved. One of the problems that we see is that, the banks are being deputized to become law enforcement officers by this rule from Treasury, and it's costing literally millions and millions of dollars. One large bank I was talking to actually has over 1,000 employees that do nothing but take care of BSA, MLL, and now they're going to have to deal with this beneficial ownership situation. So, Mr. Green, you tell me that you've been involved with FinCEN for quite some time, and you kind of like the rule, according to your testimony. Can you tell me, do you think FinCEN could be able to collect the information by themselves? That's what we propose in our bill. Is that going to work or not?
Thank you, Mr. Chairman. If by that you mean, if they were to collect beneficial ownership directly themselves,
right,
and to make use of it, yes, I think that is a possibility.
That's a viable solution. Is that what you're saying?
It is potentially a viable solution. Yes, sir. And I also think that speaks to a separate issue, which is that there's only so much that financial institutions are in a position to gather. Putting aside the burden just as a practical matter, I think Mr. Baer mentioned some of the circumstances that, as useful and as important as the CDD rule is, there are types of information, it's companies that will not be covered by it in terms of beneficial ownership information. And that would include, for example, an LLC that's established in Delaware but keeps its accounts overseas and directs its operations overseas. That would not be covered by the CDD rule because it would not be banking with a U.S. financial institution.
I had my taxes filled out during the about a month ago, and I asked my accountant. We had this situation, this problem, and I said, is there another way that FinCEN could collect the information? And he said, IRS already has all this beneficial ownership information. And since IRS is within the Treasury Department, which is where FinCEN is, you would think you would be able to just give them a call and say, hey, can you give us this information with regards to XYZ company? Is that a viable solution?
Thank you, Mr. Chairman. I have not, I will confess, I have not looked at the specific beneficial ownership information available to the IRS. I do know that in the past there have been legal impediments to using taxpayer information for purposes of financial threat analysis on the FinCEN side.
Okay, but according to my accountant, they already have this information because you have to file it when you file your tax returns. And so if we could do something in the bill, for instance, to say something to the effect that we would allow FinCEN to have access if they have some sort of cause to be able to go looking for this information. Would that be a viable solution?
Certainly, I think that FinCEN could make very good use of any beneficial ownership information that might already be in the government.
That would certainly streamline things, wouldn't it? Ms. Martinez, you were adamant in your discussion here, in your testimony a minute ago, with regards to concerns you had about, and to me it's a really real problem with regards to de-risking. And some of the banks, if in order to get rid of this problem, may just not take these kinds of customers on. Would you like to elaborate a little bit on the de-risking problem here? We see this throughout all sorts of other things going on right now, and it seems like we're compounding the problem here with this rule.
Thank you, Chairman. Yes, that is very true. The issue of de-risking is very real in all financial institutions, and it is primarily a result of the fact that there is not definitive guidance, and so individual examiners from exam to exam may change their position on how they evaluate certain types of accounts and the requirements that they ask the banks to follow for documenting risk on these types of customers. So at some point, it just becomes too burdensome to continue to ask for information from the customer, or the customer just gives up because we're asking for too much information. And so we de-risk that account or group of accounts, and that customer goes to another financial institution and starts all over again. I don't think that helps our goal here of trying to combat money laundering.
My time's about up. I just want to ask you for one more quick comment. You also talked about the problem with the lack of clarity with regards to some of the guidelines. You'd like to just take a couple moments and elaborate on that as well?
Well, I'll talk about the 25% beneficial rule. In FinCEN's FAQs, they talk about that the banks can use another threshold, a lower threshold for accounts that they deem higher risk. I think that's very dangerous, that we don't have a bright line, because that will leave the examiners open to interpretation.
Thank you very much. With that, we'll go to the ranking member, Mr. Clay from Missouri, for 5 minutes.
Thank you, Mr. Chairman. Let me thank the witnesses for being here. Mr. Carlman, to what extent does FinCEN's final CDD rule address the deficiencies that have been cited by the Financial Action Task Force as part of its periodic reviews of our nation's anti-money laundering and counter-terrorist financing framework?
Thank you for the question. It addresses some of it. The Financial Accounting Task Force has issued several reports, two, I think one in 2006 and one in 2016, calling out some deficiencies in our anti-money laundering regime. They actually did say that we had some very strong rules, but where we were lacking was in the collection of beneficial ownership information and in requiring due diligence requirements upon the gatekeepers to the financial system. And that wasn't just the banks, that was real estate industry, accounting industry, some others. So this addresses a piece of the puzzle. It's a positive step forward, we would argue, but it is not complete.
During FinCEN's rulemaking process, some commenters questioned whether the requirement to collect and verify beneficial ownership information would be more appropriately placed on state governments responsible for the formation and registration of legal entities, and or alternatively on a federal entity such as the IRS or FinCEN. Can you discuss why it is important to require financial institutions to collect and verify the beneficial ownership information of their legal entity customers, and separately to also require states, FinCEN, or some other federal entity to collect this information as part of the company formation process?
So actually, as Mr. Green alluded to, I think there's two different purposes for the different entities to collect. So one, as a matter of fact, there's a quote that I had found when I was preparing for the testimony from Jennifer Shasky, formerly of FinCEN. It said the two initiatives, the CDD rule and beneficial ownership draft legislation, dovetail together. The CDD rule focuses on financial institutions knowing who the legal entity customers are, regardless of where the entities are formed. And then the proposed legislation focuses on making sure the legal entities are formed in the United States are more transparent to law enforcement, regardless of where the conduct of the financial activity is. So there's two separate things. We would argue both are important if we're really going to plug the holes.
I see. In what ways does the CDD rule complement proposals pending consideration before this committee to require the collection of beneficial ownership and information as part of the company formation process?
So
How
again,
does it complement it?
yeah, so again, if law enforcement is to get a full picture and know both where the legal activity is taking place and at the state level, we think that both are necessary for law enforcement to have the full picture. And so we do very strongly support the proposals in the committee, Mr. Luetkemeier's proposal with Mr. Pierce, Ms. Maloney's proposal, and we think both are necessary if you're actually going to look at the full picture and make sure that there's not loopholes through which the criminals can slip.
Now, has law enforcement complained about the process, or do they find it to be effective? Ms. Martinez, does law enforcement find this process to be effective or not?
I can only share with you anecdotal information from law enforcement or FinCEN, and I can also share with you my own personal experience. I can tell you that of the thousands of SARs that we file, I can tell you there's less. I have an example of less than half a dozen cases that I know of that had actually turned into some sort of a prosecution. I'm not saying the information is not helpful. It possibly is. However, there is insufficient transparency from FinCEN to the financial institutions as to how helpful that information actually is.
So you don't get a response back once the information is turned in?
Very, very, very rarely.
I see. And my time is about up, Mr. Chairman. Thank you. I yield back.
Okay, we next go with Mr. Tipton from Colorado. Is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank the panel for being here today. I believe that the customer due diligence rule is well-intentioned. In my district in Colorado, which has a high amount of drug cartel activity, its effects will be felt. Being able to share some of that beneficial ownership information with law enforcement will help some of the and effectively combat bad actors in Colorado and across the country, which will in turn make some of our communities safer. That being said, I also believe that the rule needs to be implemented in a common sense, harmonized manner that takes into account the burden of collecting the information and sharing it with law enforcement and what that will have in terms of impact on our financial institutions. And Mr. Bear, I'd like to maybe start with you. You mentioned in your testimony that recent guidance from FinCEN detracts from the clarity and predictability of the CDD rule. Would you briefly discuss why clarity, predictability in these kinds of rulemakings is important for our financial institutions?
Sure. Thank you, Congressman. I think just to start in a most general matter, I think clarity is really important, not just only in the rules in general across any type of regulation, but particularly in this area where we have this very odd construct where FinCEN is the rule writer, but has delegated and I would argue abdicated responsibility for the examination of the institutions subject to those rules. So as I think several of the witnesses have alluded to, enforcement really comes through an examination process through the banking agencies and other federal financial regulators. They are not regularly in touch with FinCEN. FinCEN does not set priorities for them as any other law enforcement or intelligence agency would for those who are deputized for carrying out the activity on the ground. So that's why in this area, we're quite concerned to the extent that there are any gaps or vagueness in FinCEN's rules or guidance, because that will be resolved, unfortunately, through a series of examinations with examiners having different opinions, potentially agencies having different opinions, and all with banks being at extraordinarily reputational and enforcement risk to the extent that they get anything wrong. So, for example, the example a couple of us talked about with the auto renewals of CDs, it's effectively impossible for banks in a 1-month period to produce a system where they are reconfirming customer account on a rollover of a CD. So they are now effectively going to have to be inconsistent with that guidance, which is not a rule, but really to honor their contracts. But we don't know what the banking agencies are going to do on the ground when they examine them.
So it'd be fair to be able to say that the covered entities really don't have a clear understanding of what areas to be able to focus on to ensure that they can comply with the CDD rule.
I think in some areas they do, but I think there are certainly other areas where they do not.
Right, do you have a comment on that, Ms. Martinez?
I think the regulation is pretty simple, but the execution of the regulation is very complicated. And so I think that the current FAQs that are out there, while they are helpful, they're insufficient.
Right. You know, a consistent theme that we touch on in this committee is the need for harmonization between the regulators and the rulemaking. As FinCEN is not the supervisory or examining agency, which you've spoken to in your testimony when it comes to reviewing BSA and AML compliance, do you think that the federal banking regulators are familiar with CDD to conduct a fair and effective BSA reviews? Mr. Bear?
I think certainly their task has been somewhat complicated through the recent FAQs, which have opened up some new issues. I think really time is going to have to tell, I think as Ms. Martinez indicated, as they fan out to examine the thousands of institutions subject to this rule, we don't know what approach they're going to take. I mean, clearly there are issues yet to be resolved, and I think FinCEN has every intention of attempting to be helpful, perhaps providing further guidance, but they ultimately are not the ones who decide whether they're going to give a bank an MRA or formally or informally sanction it for perhaps a technical violation of this guidance.
Right. You know, and I'd like to follow up on a comment Ms. Martinez she'd mentioned in regards to having a bright line. You need to know exactly what you're going to be dealing with. Community bankers in my state of Colorado, they raised concern that the rule is going to have a negative effect on their volume of business when we're talking about having to re-verify a customer that's just having a CD rollover. So what are some of the real impacts that you'll see in that area?
Well, the problem is that there's one unanswered question. FinCEN says that the information should be gathered at account opening. FAQs now say that a CD rollover is considered a new account opening. And so if we're to gather that information at account opening, if the customer's not present, as I described as the case with CD rollover accounts, then how are we to obtain that information other than by mail or some other method? And so if the customer's not present, then the account technically can't be open. I'm assuming, I'm not sure, because FinCEN hasn't been clear about that.
Great. Well, thank you for your testimony. My time's expired. Thank you, Mr. Chairman.
Gentleman's time has expired. With that, we go to the gentlelady from New York. Ms. Maloney is recognized for 5 minutes.
I want to thank the chair and the ranking member and all the panelists for addressing this incredibly important issue. It's one that I've been working on for over 10 years. And the problem that we're trying to address is simple. Criminals and terrorist financing have always used anonymous shell companies to finance their operations because they never have to disclose who actually owns them. And there's no way for law enforcement to figure out if a transaction conducted by a shell company was actually done by a criminal organization. It was actually in response to law enforcement in New York City who came to me with the need to crack down on this because they would go right up to the beneficial owner, to the LLC, and then they couldn't get any more information. The solution is really a simple one. Companies should have to disclose their beneficial owners at the time they are formed. But because no state requires companies to disclose their beneficial ownership, FinCEN passed a rule in 2016 that requires banks to identify the beneficial owners of any companies that open accounts with them. FinCEN's customer due diligence rule is very important because it is the first step towards cracking down on this anonymous shell companies, and it will ensure that criminals and terrorists aren't using our financial system to operate their schemes. But the FinCEN rule by itself is not the solution. Ideally, companies would be disclosing their beneficial owners when they are formed, and then financial institutions would have access to this beneficial ownership information so that they can assure themselves that companies that open accounts with them are not criminals or money launderers. I'd like first to ask Gary Kalman, and we've worked together on beneficial ownership for years, and I want to thank you and the FACT Coalition for your constant focus on this. You noted in your testimony that you believe the FinCEN rule is important, but it is not sufficient in itself. If Congress were to pass a beneficial ownership bill, like the bill I've introduced, would that complement the FinCEN rule, or would it replace the FinCEN rule?
Thank you for the question, Ms. Maloney, and thank you for your leadership as well on this issue. We think that it complements the rule. It's not a replacement. We think that the legislation you've introduced will cover companies that bypass the financial system and avoid banks, so you're having much broader coverage. One thing I would also add, which I didn't say before, is we actually also think that it is helpful, and the folks on this panel can correct me if they disagree, but I think they'll say that this is a help with financial institutions, realtors that may be, if we give access to other gatekeepers to the financial system, then this helps the entire system function and gives law enforcement the information, the tools that they need. So we actually think it's not only good for cracking down on bad behavior and illegal and illicit activity, but we also think that it serves as a help to the other institutions we're asking to help us with cracking down on.
And that leads to my next question, which I'd like to direct to Mr. Baer. You noted in your testimony that the FinCEN rule is burdensome for banks because it puts all the onus on the banks to collect beneficial ownership information. And I agree with that statement, particularly mid-sized, smaller banks. They are having tremendous trouble gathering this information. The responsibility shouldn't all be on the banks. Banks are required to know their customers, but it shouldn't have to be this hard to get to find out actually who they are. And would passing my Corporate Transparency Act help alleviate this burden on banks?
Congressman, yes, absolutely. I mean, I think it just makes common sense. It makes much more sense at the
How
time.
much regulatory relief would passing my bill mean to banks?
I think substantial, and it's funny. It's just so much simpler as a common sense matter to say at the outset when you form your company who owns it, and then each bank can rely on that information. Every bank doesn't have to redo that work.
And finally, if Congress does pass a beneficial ownership bill, should the definition of a beneficial owner in the bill be exactly the same as the definition in the FinCEN rule, or should the bill's definition be broader than FinCEN's definition in order to ensure that all the beneficial ownership information is compiled? Mr. Baer, quickly, I'm out of time.
I mean, I think ideally they would be consistent. The one bad outcome would be if the CDD rule were broader, because then compliance with the beneficial ownership legislation would not suffice for CDD. So some could argue perhaps it should be broader, but I think ultimately the best idea would be consistent.
Okay, thank you.
Gentlelady's time has expired. With that, we go to the gentleman from Georgia. Mr. Loudermilk is recognized for 5 minutes.
Well, thank you, Mr. Chairman. It's my understanding that that financial regulators may expect institutions to collect beneficial ownership information at a lower equity interest threshold, and failure to do so may result in negative examination findings. In fact, in their latest FAQs, FinCEN states that, and I'll quote, "Financial institutions may reasonably conclude that collecting beneficial ownership information at a lower equity interest than 25% would not help mitigate the specific risk posed by the customer or provide information useful to the financial institution in analyzing the risk. Rather, any additional heightened risk could be mitigated by other reasonable means, such as enhanced monitoring or collecting other information, including expected account activity in connection with the particular legal entity customer." Mr. Baer, what risk posed by the customer may be mitigated by collecting beneficial ownership data at a lower threshold?
Thank you, Congressman. I mean, we strongly support a bright line rule of 25%. We believe that's the clear intent not only of the CDD rule, but also the guidance issued by FinCEN. And we believe in just about every case that is certainly sufficient to have people on the hook and searchable by law enforcement if they are interested in a company and want to know who owns it. A 25% threshold, we believe, is sufficient. There certainly may be cases where monitoring or investigation of a company leads you to believe, well, this is a case where people have below 25% ownership, but there's some reason to think maybe they're acting in concert or something like that, where yes, we would want to have reporting at a lower level. But we believe strongly that should be on a facts and circumstances basis, on a risk basis, by an assessment by the financial institution, and that rule shouldn't get rewritten by guidance or interpretation.
Right. Ms. Martinez, do you have any thoughts on this?
I think that most of my colleagues would agree that financial institutions take this responsibility very seriously, and we're personally responsible for the programs in our bank. So when we see risk, then we want to address that risk. And I agree that we should have a 25% bright line, but it should be up to banks to decide if on a risk-based approach, they should look at an account differently. I don't think that should be left to examiners, because individual examiners have different types of customer groups that they just are concerned about. And so then they force banks into lowering thresholds that are not clearly defined by the regulation, and that hurts customers.
Okay. Mr. Bear, would lowering the threshold provide additional information that would otherwise be more useful to you in analyzing the risk?
Again, Congressman, I think generally the consensus, and certainly, I mean, I should emphasize, FinCEN did a very rigorous and comprehensive notice and comment rulemaking on this, and I think ultimately they concluded, as I think most financial institutions concluded, that a 25% threshold is appropriate, it strikes the right balance, and that's enough to know about the ownership of a company. Again, there can always be cases where banks may have reason to investigate further, but we think that suffices for law enforcement purposes.
One quick follow-up. If a financial institution chooses to collect beneficial ownership information to the 10% level on some high-risk customers, they must then clearly distinguish to which high-risk customers the lower threshold would be applied and choose how soon that information must be collected after the high-risk designation. So what if the customer fails to comply or fails to comply in a timely manner? Will the financial institution close the account because the customer is non-cooperative, even though the actual regulatory requirements for the collection of beneficial ownership information have not been met or have been met?
I may defer to Ms. Martinez on this. My assumption is that if the customer refused to provide that information, in all likelihood, you would file a SAR and then perhaps close the account.
You just described one of the primary reasons that banks de-risk.
Okay. Thank you. I yield back, Mr. Chairman.
Gentleman from Georgia yields back. With that, we go to the gentlelady from California, the ranking member of the full committee. And we're going to recognize her for a point of personal privilege, and then we'll recognize her after that for 5 minutes of questions. She's now ready to go.
Thank you very much, Mr. Chairman and Ranking Member. Before I begin the questions, I'd like to first recognize the hard work of one of my staffers, Kirk Schwartzbach, as today is his last day after more than 10 years on the committee. Kirk came to the committee in 2008 and started at the front desk. Today, he now manages a portfolio that spans monetary policy, currency and coins, various consumer protection issues, international development, and counterterrorism and illicit finance. Beyond being a brilliant individual, Kirk is also very friendly, warm, and caring. His compassion to advocate good policy on behalf of Americans he may never meet is only surpassed by his dedication. Kirk is not going far, as he's going to be joining the Congressional Affairs Office at the Federal Reserve. But certainly, we're going to miss him. Thank you, Kirk.
Gentlelady is now recognized for 5 minutes for questions.
Thank you very much. As you know, FinCEN began the process of developing its customer due diligence rule in March 2012, and that was more than 6 years ago, when it issued an advance notice of a proposed rulemaking. After a 4-year rulemaking process in 2016, FinCEN finalized the CDD rule and provided covered financial institutions a 2-year delay before they would have become compliant, which will be on May 11, 2018. Do you believe that this 2-year delay was adequate with respect to giving banks time to put the necessary processes in place to collect this information? And this is Mr. Coleman.
Thank you for the question. We do, as I said in my testimony, we think that it's reasonable. Banks have had 2 years to comply with the rule, and it's reasonable for the rule to go into effect. We don't see a need for delay. I did also say, and for banks that, like, if there's banks that have ignored the rule and didn't do anything, then they need to do so. But for those banks that did take good faith efforts, and there is some misinterpretation, not misinterpretation, that's the wrong word. If there are some banks that, because of the FAQ that has created confusion, feel that they are not in compliance, we don't take a position on a reasonable time-specific accommodation in terms of enforcement.
Okay, I'm going to move on. Mr. Kelman, also in your testimony, you emphasize how criminals can use shell companies to facilitate their illicit activity. How would CDD rule and beneficial ownership legislation help curb the flow of illicit funds by criminals, kleptocrats, human traffickers, and terrorists? For example, in 2013, prosecutors in New York charged 34 alleged members of Russian-American organized crime groups with a range of racketeering activities, which includes one group that was alleged to have moved millions of dollars in illicit funds through a network of shell companies in Cyprus and the United States. Would the CDD rule or beneficial ownership legislation prevent this?
So in my written testimony, and let me highlight it here, I think it's a critically important issue for us to be raising here, that this is not an administrative exercise, that this impacts real issues that threaten the financial system and individuals in our society. The issues range from, as you said, national security issues, kleptocrats hiding money. We also see it in the opioid epidemic, anonymous shell companies used to move illicit drugs, human trafficking examples. We recently had Polaris, one of the largest anti-human trafficking organizations, join our coalition, specifically because law enforcement can't follow the monies. There's numerous examples in the legislation that you've co-sponsored with Ms. Maloney would crack down on this, and we think it would have a foundational impact on these issues and lead law enforcement to better be able to crack down on the wrongdoing.
I'm a bit curious. Cyprus comes up quite often when we're talking about shell companies, when we're talking about money laundering. Do you have or know or understand information about what's going on with Cyprus and its role in, money laundering and shell companies?
There may be others that Mr. Green has
Anybody
more information
can,
on Cyprus. Let me say one thing that I do think is important because it's come up in numerous conversations very quickly, that the issue is if we close down our system to this money laundering, won't they just go overseas to some of these other jurisdictions, whether it be Cyprus or the Cayman Islands or what have you? I would like to say that the European Union and many of our allies have already moved to collect this information. If we voluntarily choose to move forward and do the same, the remaining nations, I have been told, would follow suit. Right now, those places like Cyprus, the Cayman Islands, BVI, what have you, all point to the United States saying, why should we do this? The United States doesn't. So we do believe that if we take leadership in this, the rest of the world will follow, and we can actually have a substantial impact globally.
Anyone else have something quickly to say about Cyprus?
Yes, thank you, Congresswoman. I would just say that I think Cyprus has been an attractive jurisdiction for a variety of actors because it's seen as a favorable jurisdiction for offshore banking and also one that protects the privacy of companies that are established there, sometimes referred to as bank secrecy jurisdictions. And, I think you can see that sometimes that can go awry, as has happened in the recent designation of FBME by FinCEN for 311 sanctions.
Thank you. Yield back.
Gentlelady's time has expired. With that, we go to the gentlelady from Utah. Ms. Love is recognized for 5 minutes.
Thank you. Thank you so much for being here today. I've heard a little bit of consternation about this rule from the banks in my state, who don't think that they're best positioned or the best positioned entity to gather this due diligence. And they wonder why this due diligence isn't conducted by the various states' corporation departments which register the business. On the other hand, banks have already been forced to develop extensive FinCEN compliance procedures, and this would seem to just add new wrinkles to those existing procedures. I'd like to hear your thoughts on the relative merits of having banks conduct this particular form of due diligence. The burden has to fall somewhere, but I guess I'm just trying to figure out why the banking institution has to be the place where it goes. Yeah, go ahead.
Sure, thank you, Congressman. Well, I mean, the CDD rule is actually broader than just beneficial ownership. It involves an obligation to know the customer and monitor for suspicious activity. And to do that, you actually have to know who are you monitoring. So the question is, when you start with who the beneficial owners are, is that something the bank should have to do and each bank do potentially for the same customer over time? Or is that something that just should be collected as the legislation would intend at the outset of the formation of that company? I think banks would tell you they're not trying to avoid their CDD requirements, but it certainly would be much more efficient and probably more accurate if they could just draw on a database. I think the draft legislation envisions FinCEN, and just go to that database and say, okay, here are the beneficial owners of this company, and that's who I'm going to monitor for suspicious activity.
Ms. Martinez, what kind of resources does an institution need to devote this additional rule, and how does this affect cost to the institutions?
So I talked about this in my opening statement. Just for IBC, we spent 2,912 hours just designing and testing all of our programs and our policies. And it's taken us about 7,800 hours to train our employees on this new rule. And this is an ongoing effort because there's still not enough clarity.
Right.
I would like to address your point on why the burden is on the banks and not on the states. I'm in Laredo, Texas, which is on the border of U.S. and Mexico, and I'll just use Mexico as an example. I'm not saying or advocating that this is what we should do, but just as an example of what Mexico does, and they've done this for many, many years. Every state in Mexico is required to register businesses, and financial institutions can rely on that information, and that beneficial ownership information is at 1% and above. Okay. And if there's a change to that company structure, there's a formal federal process that the company has to go to register those changes. Okay. So I think we should be partners with the states, and we shouldn't bear the entire
instead of
burden.
trying to do two separate. Okay, so what areas should FinCEN and the regulators be working on to address the, you talked about clear understanding, and that clearly is an issue. So what do you think the areas should FinCEN focus on so that we can address that first and foremost? Because that, I can see already using resources on trying to figure out what information, clear direction on what to do, so.
I think there's two that come to my mind right away, and the first one is this issue with the auto-renewable CDs. So if you're a business customer and you bank with 4 different banks in your city, and you have 4 different CDs that all auto-renew at a different time, you're going to be required by your financial institution to provide beneficial ownership information the first time that CD renews after May the 1st. So 4 different beneficial ownership attestations will need to be provided. So if you're a larger business and you've got 4 certificates of deposits and 4 checking accounts, and then you have a change to your organizational structure, now you've got to go to 4 different banks to make those changes. And that is, I think, a burden on our small businesses that are not exempt by this regulation.
Okay, thank you. And on the flip side, what action should FinCEN and regulators take to ensure financial institutions aren't over-collecting information? I mean, you're thinking about different information that has to happen very quickly. You've got different entities. How do we ensure that there's not over-collecting?
Well, I think that's a very good question, and I think we should all ask FinCEN that question. The problem is also that not only are all the financial institutions having to collect all this information, but it's not going to be used unless we receive a subpoena, and there's nothing to verify it against. Yes, there's verification for identification of the beneficial owners, but there's no corporate document that banks have to verify the percentage of ownership that the customer is attesting to. So how valuable will that information even be to law enforcement?
Very insightful. Thank you so much. I yield back, Mr. Chairman.
Gentlelady's time has expired. With that, we go to the gentleman from Washington.
Thank you,
Heck,
Mr. Chairman.
recognized for 5 minutes.
First, I'd like to start off by saying in the 5 years and 4 months I've had the privilege and honor to sit on this committee, we've received testimony from an incredible number of interest and stakeholders, ranging from consumers seeking to protect consumers to those who are regulated. In all that time, Ms. Martinez, I don't think I've ever seen testimony presented as strong and clear and supported as yours. You're a credit to your profession, and I just wanted to thank you for that. I also want to say that when I talk to bankers back home about compliance, and I do all the time, I ask them, what's really frustrating you? What's getting you down? And every single one says BSA and AML. Every single one. And I've kind of come to the conclusion, as somebody not from the industry, except had a cup of coffee in it 40 years ago, that it really is born of two factors. And the first of which seems to be it's a one-way ratchet, and it's getting tighter and tighter. Requirements are always getting more difficult, and there isn't any countervailing effort within the regulatory context to seek to ease that, it seems to me, or to lighten BSA compliance in other ways. And the second is that it's, as alluded to here earlier, just frankly not very transparent. The bankers in my district, as Ms. Martinez reflects, really believe in the mission of BSA and AML. Nobody doubts that. And they put a lot of time and effort into complying with it. Thank you for documenting it again, Ms. Martinez. But they have no idea if they're helping. They really don't. Not a single one of my community bankers, not one, has ever told me that they've received a follow-up from a law enforcement agency on a SAR or a CTR. Not one. So the first problem, I think, about the one-way ratchet is at least partially on us. We contributed this here in this institution, unfortunately. We've been ignoring this hue and cry and the recommendations that we kind of backed down some. Part of the evidence of that, to invoke the 800-pound elephant in this room, is that both chambers have passed packages of major regulatory relief. And we hear a lot from back home about the need to do this. Not one line, not one section, not one provision relating to BSA MAL. The number one complaint, nothing is being done in it. And I'm not pretending like this easy. It's a Gordian knot. My friend, Mr. Lukemeyer, has been working on this for a couple years. I know it's hard. So the second problem is really what I want to quickly, since I've managed to speak for most of my time, get your thoughts on, and that's the issue of just how darned effective is the Bank Secrecy Act? How efficient is it? Is anyone reading SARs that are filed? Does anyone review the CTRs? Are they just kept in a database to be used if there's a lead that comes up? And if nobody's reading them, does it make more sense to just have the banks keep it and make it available should somebody need it? Or if people are reviewing the reports, for which I haven't received much evidence, indications otherwise, and acting on leads that they generate, what can we do to demonstrate to the people like Ms. Martinez that all of their time, effort, and money devoted to this is actually making a difference? That's a big mouthful of questions. Mr. Green, you win. 1 minute and 16 seconds.
Thank you, Congressman. I appreciate the opportunity to answer this question, having been inside FinCEN and seen the value of SAR reporting. I think you touch on an issue that FinCEN, I know during my time there, was very concerned about, which is the lack of feedback about the value of SARs and their utility. I can tell you from having seen inside at FinCEN, SARs are immensely useful, and so is a lot of the other reporting that is required under the Bank Secrecy Act. I was particularly impressed by their use in combating terrorism and in informing investigations related to terrorist attacks, both within the both abroad and also activities within the United States. And so I think they play a critical role, but I think that there is some regulatory fatigue that has set in among the regulated financial institutions that have to comply with the Bank Secrecy Act, and they need to understand the value of those SARs, number one. So it would be nice to have some method of feedback to industry to explain to people when a particular SAR has been useful. That would require some collaboration with law enforcement. But more broadly, I also think there needs to be some flexibility in the approach to enforcement of the BSA requirements so that we're really focusing on enforcing against parts of AML programs that really address the particular threats that the country is facing at any given moment. Thank you.
Thank you, sir.
Gentleman's time has expired. With that, we go to the gentleman from Texas. Mr. Williams, recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for holding today's hearings. Criminals and other bad actors wishing to do harm to Americans have used the U.S. financial system for many years to hide their illicit activities. Because of this abuse, it's always been important for financial institutions to remain vigilant, and that is why anti-money laundering and counter-terrorist financing regimes are so crucial. Implementation of the FinCEN customer due diligence rule is rapidly approaching, as we've talked about, and so testimony from the various stakeholders and experts before us will be crucial in determining whether or not we are on the right track. So first question to you, Ms. Martinez, and I'd like to add you work for a great group of folks. I understand that the bank that you're with devotes a lot of resources to complying with BSA regulations. And as you know, one of the key components of BSA compliance is the filing of suspicious activity reports, or SARs, as we've talked about. So how does your bank identify potential SARs filings? And further, do you find that the information you provide law enforcement is useful to them? And do they give you any kind of feedback at all as we've spoken?
So I've been told that this is my hobby horse, so thank you for asking me that question. At the bank, and most financial institutions work this way, we have a surveillance system. And this surveillance system is made up of a series of rules that have various thresholds on different types of transactions. We review hundreds of thousands of alerts on an annual basis. Those hundreds of thousands of alerts give us several thousand transactions that we need to investigate. Of those thousands of transactions that we investigate, we end up with a smaller number of suspicious activity reports that we file. I have been BSA officer at IBC for 27 years. We do at times get requests from law enforcement for supplemental information. There are law enforcement task forces that look at these SARs, but there is no transparency from FinCEN with regards to this data. I have no idea of the thousands of SARs that we file at IBC, how many of those were helpful to law enforcement, what percentage of those SARs were helpful to law enforcement. And I believe that FinCEN has a responsibility to give us that transparency. We believe in these regulations, and we take our corporate responsibility very seriously, but let's develop rules that make sense for all of the stakeholders.
Okay, again, let's talk about onboarding process for new customers. 2016 Thomson Reuters survey of companies discussing their onboarding process with a bank found that 30% of the respondents reported an onboarding time of more than 2 months, and 10% claimed an onboarding time in excess of 4 months. So if companies have to wait that long to do business with yours or a similar institution, they may decide to take their business elsewhere. So will the CDD rule increase onboarding times for new customers, and are you at risk of losing customers because of it?
Yes and yes. And so I spoke about that earlier. Rarely is the business owner the one that walks into the bank to open the account. It's usually the controlling person. We're now required to identify the beneficial owners. The controlling person will not have the identification for those beneficial owners. So I anticipate that it's going to be very rare that we're going to be able to open an account when that individual actually wants the account opened. Even today, sometimes it takes months to collect all the corporate documents that we need to collect from customers. And so I think it's a very big danger for our small business customers.
Okay, Mr. Green. As we all know, the May 11th implementation date of CD rule is rapidly approaching, as we've talked, and however, FinCEN early this month released an additional set of FAQs to assist institutions in compliance. So do the recent FAQs give institutions the needed clarity to meet compliance standards, or does FinCEN need to offer technical corrections or the other changes to the regulation?
Thank you, Congressman. I think that the FAQs take care of a number of the questions and concerns that industry had raised during the 2-year period where they had a chance to kind of work on implementation to the rule. I do think there are some questions that are still outstanding, and I think that that's going to require close collaboration with FinCEN to get those questions answered, and that FinCEN needs to address those and provide extra guidance where needed so that institutions can meet their obligations. I also think that during this, once the May 11th implementation date arrives and they go forward into implementation, FinCEN needs to demonstrate some leniency and flexibility with the inevitable issues that are going to arise as people start to implement. Even if they were to resolve tomorrow all the issues that are raised by the FAQs, there are going to be other issues that arise as people start to actually implement these rules, and they just need to be patient and flexible, as Mr. Coleman had suggested. Thank you.
I yield my time back. I'm grateful for your all's testimony. Thank you.
Gentleman's time has expired. Without objection, gentleman from New Mexico, Mr. Pierce, gentleman from Arkansas, Mr. Hill, are permitted to participate in today's subcommittee hearing. While not members of the subcommittee, they are members of the full financial subcommittee, and we appreciate the participation today. They have just called votes. I think we can be able to, hopefully we'll get both gentlemen in before we need to leave. And with that, we recognize Mr. Pierce from New Mexico for 5 minutes.
Thank you all, and I appreciate your testimony today, Ms. Martinez. You're kind of at the intersection of what we're struggling with on this legislation. So see if we can lean into the deal here. We'll get to you there. So you talk in the first paragraph or the section 1 that at the end of it, you talk about helping our law-abiding customers achieve financial success, and believe me, I'm on your side in the argument, but I find myself on the other side of the policy, and so it's trying to harmonize those two positions, because it's exactly that says that willingness to help our law-abiding customers achieve financial success. It says we got to do something on beneficial ownership, because it's my home county where a lot of trucking in the oil field, and people show up with a lot of money, they buy brand new trucks, and they can have new trucks all along, and so they compete better. They don't have to make a profit. And so what it's doing is actually taking away the possibility of the law-abiding companies to make a profit, because they can price anywhere they want to. Again, they're getting free money from drug traffic or somewhere. And so that drives me. How do you all evaluate that when you're, I understand the core value of helping our law-abiding customers achieve success, but if they can't be successful because the market is rigged by people who have shell companies, how do you just think about that particular intersection of the question?
I think it's very important for us to try to solve the root cause of the problem and not the symptoms.
What is the root cause?
The root cause is that beneficial owners should be identified at the point of formation. I agree with Congressman Maloney and what she said earlier. Why should the burden be at the bank level only? It should be at the time that the company is formed. That's the best time for the identification of beneficial ownership to be done, and transparency to that.
But you understand that, I don't mean to interrupt, but we got a vote coming and everybody's trying to get their questions. But so you get the beneficial ownership at the time that the company is formed, and then people trade shares, and so they show up at the bank. And even if I look down in the second point, and you're talking about that the control person at the company may not know who the beneficial owner is, and to me, that seems like a problem that a bank would want to cure. If a control person doesn't know who the beneficial owner is, I think that should send off alarm bells, but you presented, and again, I'm sensitive to your side. Normally, I find myself on your side of the equation. But we're really struggling because the testimony is that the U.S. has become the haven for shell corporations because we're so lax in every regard. And do you feel like that the control person should maybe know who the beneficial owner is before they're allowed to be the control person?
Yes, I do, and I think all of that should be discussed and and entered into record at the time the company is formed. Back to the example that I used in Mexico, that's what happens at the state level when a company is formed. And if there's a change in ownership, that has to be registered at the federal level, and then it has to be re-registered at the state level. Then we can rely on that information to be accurate. Right now, I'm basing what a customer's telling me on their attestation. I have nothing to verify that against.
Yeah, so your position is based on the fact that people who are willing to sell drugs and create illicit profits are going to tell the truth about.
No, I think
they're going to tell the truth about who the beneficial owner is when they incorporate, or when maybe they just come in to start the bank account and they say, and they're going to tell you the truth.
I think
I don't believe that.
I think that's FinCEN's position, which is why they're allowing for the beneficial ownership attestation.
Know that we in the Counterterrorism and Illicit Finance Act, we have a section. I'm going to provide that to you with approval of the chairman and all the people who's above me in this organization. And I would like your comments, because we're really trying to address the fact that that the bankers submit all these reports and nobody ever gives them feedback. I think you should actually have access to that information. It would allow the process to be a little bit more transparent. I'm going to yield back, Mr. Chairman. I'll let somebody else get to the questions.
Back.
Thanks.
With that, we go to,
I appreciate your thanks.
With that, we go to the gentleman from Arkansas, Mr. Hill, recognized for 5 minutes.
I thank the chairman. Thanks for letting me come to the hearing today. I appreciate, too, Mr. Chairman, you and Mr. Pierce supporting my effort to delay this rule for 1 year, and I'll tell you why, very, very succinctly. One, I don't think it helps us catch bad guys. Number two, we already have a rule in place that's, as Ms. Martinez looked at, is very hard to comply with, and this is made more difficult. But the principal reason I object is due to Mr. Pierce and Mr. Lueckemeier's hard work. We're trying to rewrite AML-BSA for the first time in a comprehensive way, and it seems to me to introduce a new complex beneficial ownership rule in the midst of trying to get it right statutorily is a distraction to the banks, in addition to a costly distraction. So I would like to know, Ms. Martinez, you support delaying this rule?
Yes, I do, along with many other bankers.
Yeah, and so I want to be clear, though, that I think secretaries of state should have best practices where they have an active email address, an active phone number, an active name for an agent for every incorporation in the country. Absolutely. And that they have some requirement in their state that there's a penalty associated with being inaccurate. I think that's good. That's not in our federal jurisdiction, but that's an important thing. And then I would like to argue again in front of this panel, as I have for 2 years now, that we do have accurate beneficial ownership information in this country at least once a year when we file the tax returns for every one of these pass-through entities. And I believe the burden's on the federal government and the executive branch to work with the legislative branch to see how best to use that data, because it is accurate. They can change ownership during the course of the year, no doubt. But to have a simultaneous knowledge of every time someone changes ownership in a company in this country, that isn't going to happen. That's not possible. That is unreasonable. And so this idea that the IRS has pass-through ownership down to 0%, 25 basis points of a percent, not 25%. It's actually an actual reading of the ownership in every pass-through entity of someone who's formed a company and files a tax return in the United States. And that would be a great safe harbor source of information for our financial institutions. Next thing I would say is I'm not a big fan for this data, another infinite database controlled by some unknown entity that people just ping into and find out what the beneficial ownership are. We have enough trouble with keeping people's private personal information safe in this country. The IRS has failed doing it, OPM's failed doing it, Equifax can't do it, Facebook can't do it. So to create another database that people can ping into from remote access on a PC or a bank data processing system, I think bears a lot of risk. So, Mr. Chairman, I appreciate the work you're doing and that Mr. Pierce is doing. We need to design a beneficial ownership rule and customer disclosure capability that banks can easily comply with, provide the federal government the information they need. But I argue passionately, The federal government has the information we're looking for. Let's find a legal, constitutional way for that information to be shared inside the federal government. Thank you, Mr. Chairman. I yield back.
Thank the gentleman from Arkansas for yielding back, and I appreciate his passion and his suggestion. I wholeheartedly agree with it. I want to thank the panel for your participation. It's been very enlightening, and you guys have done a great job of explaining your concerns and your interpretation of the rule and the consequences of it. So, without objection, all members have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witness to please respond as promptly as you are able. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. With that, this hearing is adjourned.